Did you know that there's a 1,000-year-old court still operating in the United States and none of us really ever talk about it? I'm Brian. I make videos about law and civics, and they're not as popular as some of the others. So please comment, share, repost, do what you got to do to get this video out there so people can see it. Because this is the story of the Court of Equity. And it's part of your law, so you should understand it. Right here in the U.S. Constitution is Article 3, Section 2. The judicial power shall extend to all cases in law and equity arising under this Constitution, the laws of the United States, etc. What is equity and why is it different from law? Let's find out. These are the federal rules of civil procedure. And the second rule in here says there is one form of action, the civil action. Which makes sense, because these are the rules of civil procedure. You're filing in civil court. Of course you're filing a civil action. But when this rule was written in 1938, it made a huge splash. Because in 1938, when these rules were passed, there were two civil actions, law and equity. And Rule 2 basically wiped the Court of Equity out of existence. But while most of the equity courts are gone, equity law is still alive and well, and I will tell you where it's hiding. Real quick, very tempting to see this as some sort of a conspiracy theory. It's not. The reality is way more boring. When I was in law school and we were learning this stuff, nobody paid attention to this. Nobody was that interested in equity. My guess is most people learned it for their exams and then forgot about it completely. It's one of those things where sometimes you have to write some different words. Wait, there's special rules that apply here, right? What's that called? But nobody pays attention to it. The only reason I did is that half the reason I was interested in law was the history. Plenty of stuff was boring to me too. So for a lot of lawyers, equity is just one of those things you don't pay attention to. You could probably go through an equity case and not even know it. But I still think it's something you should learn about, so I am going to teach you. As usual, we're going to start with some history. Historically, courts generally looked at 4 different kinds of law: government stuff, land stuff, commerce stuff, and crime. And I've explained in some other videos that commerce and land tend to be handled differently because commerce disputes can usually just be managed with money, while land we look at as something special that you can't just replace with another piece of land or some extra money. So let's take a look at how these courts were set up. So way back when, we have our courts handling property, we have our courts handling revenue, taxes, government stuff, we have our courts handling crime and civil disagreements. The only thing the king really cares about is his money and property, because the king has his finger in all the property, and obviously tax revenue is going to be his deal. King couldn't care less about local crime and petty commercial squabbles. Those are handled by small local courts and regional courts, and by manor courts. So if you're a peasant and you get screwed in a contract, you go to the lord of the manor. Think Downton Abbey. Then along comes King Henry II. Late 1100s, and he decides to reorganize all the courts. So Henry creates the Court of the Exchequer, the Court of the King's Bench, and the Court of Common Pleas. Court of the Exchequer is going to keep handling all the stuff he cares about. The Court of the King's Bench is going to be like a regular court, and it's going to handle all of the crime and any civil infractions that are kind of crimey, what we call civil breaches of the peace. And the Court of Common Pleas is going to handle all of the civil questions, so any kind of commercial stuff. Got all that? Now I'm going to make 700 years magically disappear. Court of the Exchequer is going to change its name to the Court of Chancery. It's not what really happens, but we don't have time. It's named after the Chancellor. Today, we don't really care about criminal law. But for like the next 700 years, these 3 areas of court are going to fight over who gets to control what. But in the end, it's still going to end up looking pretty much like this. All right, we don't really care about revenue anymore. But slowly, we're going to get Court of Chancery, Court of the King's Bench handling crime, Court of Common Pleas handling civil. Now, I'm going to put some more familiar names on a couple of these. The Court of Common Pleas is also known as the Court of Common Law. Court of Chancery, also known as the Court of Equity. So let's talk for a minute about the differences between these two. The Court of Common Law follows, like I said, a more structured regimen, and one of its primary defining features is what we call stare decisis, which means we stand beside the decision, or I stand beside the decision, he, she, it stand beside the decision. That means that common law courts are locked in to prior decisions made by other common law courts or by itself, and the common law court has to follow it going forward. The common law court is also usually stuck resolving things with money. So if somebody breaks a contract with you and you lose $10 in the deal, the common law court can get you your $10 back. What about equity court? The Chancery Court, Court of Exchequer, whatever it is now, has a totally different set of rules. It operates under equity. While common law is stuck with its old decisions, and common law is stuck solving problems with money, equity is less stuck to those old decisions, has a lot more freedom to make new decisions, and it has the ability to force what we call specific performance. That means it can force somebody to actually do something or stop doing something. And the reason I've been talking about property is that the equity court comes along to do things like say, hey, you have to sell your property to this guy because you agreed to do it, and we see that property is different from other things and can't be replaced with just money. Equity court is important because it fulfills a need that common law can't fill. Also, very importantly, the chancellor, who again, Chancery Court is named after, had the ability to put you in jail if you didn't follow his decrees. So we call this the equity doctrine. The courts are more flexible, they're more fair, they have a little bit more opportunity to kind of do what they want, as opposed to the common law courts that are locked in with these old decisions and with money solutions to fix problems. Equity courts are more equitable, fair, equity. Okay, so now let's talk about equity in America. That's all England. A lot of the states set up common law courts and equity courts as separate buildings. Not every state had separate courts, not every state liked equity, but a lot of states did. But unlike some of the states that had like separate buildings for common law and equity courts, the federal court system always only had one court building. Actually, let me draw this out. So up at the top, you see the judges and the buildings. In the states, sometimes were different. At the national level, they were the same person. The language of law and equity could be completely different. At least early on, actions in equity were really long and complicated. The rules of law were based on common law. The rules of equity were kind of touchy-feely. They could switch around a bit. The remedies at law were mostly money, while the remedies in equity were very different. You had a lot of flexibility to make changes. And generally, their philosophies were very different. And it was recognized from a really early time period that common law had shortcomings, and that's why equity was important. But equity also had shortcomings, so you couldn't just bring anything in equity. But then 1938 comes along, and this guy's written. And people were already getting fed up with this complicated system. So the states were also leaning towards wiping this whole mess out. So let me show you what the Federal Rules of Civil Procedure did in practice. Obviously, at the federal level, we didn't have two sets of judges and two sets of buildings. But as the federal rules took hold, a lot of these separate systems either were already wiped out or were wiped out entirely. The only one to still exist is in Delaware, which still has a chancery court named after the chancellor. So now we just have a court, which at the federal level we had anyway. But we also only have one action. So a lot of the language is simplified too. Some of it's still different, but a lot of it's the same. Similarly, a lot of the rules get mixed together because now we have this, and this sets the rules for both. So while the law they're following is common law and equity, a lot of the rules are now the Federal Rules of Procedure. But the real problem is that the remedies stay different, and so do the philosophies. And they still exist to this day. What does this all mean? Well, today you may not even notice that there's a difference if you file a common law case versus an equity case. The differences aren't that extreme, but if you do know the difference, it might help you out a little. So let me tell you some of the biggest differences between the two. First, obviously the constitutional difference. So the writers of the Constitution knew that equity existed all the way through. But the Seventh Amendment, which guarantees jury trials for civil cases, only applies to common law cases. This was not a mistake. These guys knew what equity was, and they knew it was different from common law. So to this day, equity cases are not required to have a jury. The second huge difference is going to be the damages, the remedies. And I'm going to drop a concept on you that's a little complicated, but work with me. Common law judgments are also known as declarative judgments because the judge is always declaring something, even when it doesn't sound like the judge is necessarily doing that. Examples of a declaration might be, this contract is invalid, full stop, or you owe that person $10. Those are declarations. I don't know why, but that's what they're called. By contrast, our equitable remedies are a little bit different, a little more flexible. Again, these are things like making someone do something, making someone stop doing something. A judge in equity could find a mistake in a contract, and instead of saying this contract is completely invalid, finding some way to make it work. So whenever you come to a court and request an equitable remedy, like an injunction, specific performance, mistake, anything like that, you are filing a case in equity whether you know it or not. Another difference between the two is defenses. Both common law and equity will bar you from bringing a case like way after whatever the thing is happens. In common law, we call it the statute of limitations. It's a common phrase, you know what it means. In equity, for some reason, we call it laches, L-A-C-H-E-S. It's from a French word that means you waited too long. And one of these things that it is useful to know is if you're filing in equity, you would want to claim a defense of laches instead of a claim of statute of limitations. And most people probably wouldn't know that. But again, that's one of those things that lawyers are like, oh, this is that weird case where I have to say that laches word instead of statute of limitations, right? But they don't really understand all of the rest of this. All of this is like, it went out of their brain as soon as they took the exam. And then the final big difference is the flexibility of the judge, which is really in the philosophy. Common law is designed to be stringent. It's designed to be law. It's designed to be very, very clear. Equity is designed to be more flexible, but it's also harder to get into, because finding a solution that's fair would be really hard if you were stuck in a really inflexible system. But if you let everybody get into the system that's really flexible, then we wouldn't really need laws at all, because everything would be out the window. Okay, so where is equity today? Well, equity is in a lot of countries where England was involved in creating their legal system. So South Africa, Australia, Canada, India also have equity systems of some sort or another. The bankruptcy court is always a court in equity, because bankruptcy judges need flexibility to make sure things are fair. They're settling a lot of things that kind of inherently aren't fair, so they're given some flexibility to make changes as necessary. And then certain cases, when they're brought into civil court, are just divided into common law or equity, depending on what they are or what the remedy is. So a case for breach of contract for land, probably going to equity. A case that requires some sort of specific performance, probably going to equity. A case that requires an injunction, probably going to equity. Almost any civil case where you don't see a jury, probably equity. But if you're just asking for money or to declare a contract invalid, probably common law. Okay, so that was our quick as I can overview of equity, our secret hidden court that I find fascinating and I think is really, really interesting. I hope I introduced you to something new and that you find it as interesting as I do. Please keep watching the videos and keep sharing these, and I will keep making them if you keep watching them. Thanks for sticking around, and hope to see you soon. Thanks, guys.